Well, Ms. Dunson,
Good morning, how are
you
you?
charged with driving while intoxicated. You're facing up to 6 months in jail and or $2,000.
Right out the gate, it's clear. We're in serious trouble. DUI charges are on the table, potential jail time is looming, and the judge isn't pulling any punches. This is one of those pivotal moments where your life can swing in two directions: a shot at redemption or a fast track into chaos.
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On April 21st, 2025, in ERUPTS County, Texas, a law enforcement officer was dispatched in reference to a wrong-way driver and initiated a traffic stop of a vehicle described by the 911 call. The law enforcement officer
On April 21st, 2025, in New H County, Texas, a law enforcement officer was dispatched in response to a report of a wrong-way driver. The vehicle in question had been described by a 911 caller, and the officer initiated a traffic stop based on that information. During the stop, the officer advised the driver of her rights, stating, "You have the right to remain silent. Anything you say can and will be used against you in court. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am."
made contact with the defendant when the defendant handed the law enforcement officer an unopened alcoholic beverage. The law enforcement officer noticed the strong odor of an alcoholic beverage coming from the vehicle, and the defendant appeared unstable and fell against her car. The defendant stated she spilled a whole can of beer on herself earlier. The defendant's vehicle appeared to have fresh damage consistent with hitting the curb. Standardized field sobriety tests were conducted, where the officer observed 6 out of 6 clues in the HGN, 0 to 8 on the walk and turn, and 0 to 4 on the one-leg stand. The inventory search revealed 3 open and empty beer cans in the backseat floorboard and other unopened alcoholic beverages. The defendant considered to breath and blew .143 and .145.
What did you say the stop was for?
The stop was for, there was a 911 call that stated there was a vehicle driving the wrong way and described the vehicle. The officer found the vehicle.
Driving the wrong way?
I'm not sure. Well, the officer.
Here comes the legal twist. The vehicle matched the 911 description, but it wasn't actually seen driving the wrong way. That raises a critical question. Was there truly probable cause to make the stop? Or was this just a fishing expedition by law enforcement?
The vehicle was not driving the wrong way, but it matched the description given by the number.
Great. Anyone can call and say anything. Did he view any kind of traffic infraction? I could literally call and say, "Hey man, the state's driving nuts. Go get him." Right? I mean,
There's
Yeah.
no other
Okay.
traffic infraction.
Johnson, I'm going to find that there's no probable cause to go forward with the case. There's enough death and destruction on our streets. Now, play it safe. The last thing you need is to end up in a 6x9 because if you get into an accident, maim, kill someone, especially with alcohol in the car. Do you understand? Play it safe. Don't make any boneheaded moves. Please.
Thank you, Your Honor.
Good morning.
I have an arraignment for Miss Rice.
Do you mind bringing her up?
I do believe PC has not been found or...
Okay. Good morning, Ms. Rice. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Your Honor. On April 22nd, 2000.
Now this is where the plot thickens. She admits to having just one drink, but the field tests tell a different story. Let's be real. Slurred speech and glossy eyes usually suggest more than a single sip. But keep listening because her defense might just flip everything on its head.
25 in Harris County, Texas, law enforcement officers were dispatched to a crash call and found a vehicle inoperable due to a collision and blocking traffic. Law enforcement officers spoke to a wheel witness who stated he observed the defendant in the driver's seat of the vehicle with the engine on and advised the defendant to turn the vehicle off and exit the scene. The law enforcement officer made contact with the defendant who was sitting in the driver's seat of the vehicle and observed slurred speech, moderate odor of alcoholic beverage, and glossy eyes. The defendant admitted to consuming 1 alcoholic beverage. SFST standard field sobriety tests were conducted. A 6 out of 6 on the HGN was reported, a 7 out of 8 on the walk and turn, a 2 out of 4 on the one leg stand. The defendant refused to provide a specimen. A blood warrant was obtained and executed.
If I may, Your Honor, what the officers completely failed to leave out of their report is that the car was registered to the other person that was present. The other person had the keys on them. The other person admitted to driving. At the time of the accident, I'm not sure why they switched seats. I don't know. I do know the wheel witness came after the accident had already occurred. They had been waiting on a tow. If the officer would have done any due diligence in his research or questioning, the other person they may have been intoxicated.
It's a teachable moment. The judge drops a truth bomb. Probable cause is a low bar. This stage isn't about proving guilt. It's simply about whether there's enough evidence to move forward to trial. And guess what? That's exactly where a lot of people get caught slipping.
Not sure he didn't even follow up with them. They openly admitted, this is my car, I'm the one driving. The officer made no attempts to remedy that situation or even mention that in his report.
Any of that?
Your Honor, I would just say that, based on what we have in the DIMS, we witnessed put the defendant in the driver's seat of the car.
After the car was already inoperable. He didn't see her, he didn't see the accident.
Your Honor, I would say for probable cause purposes, we have a wheel witness that says they saw the defendant behind the driver's seat.
Of an inoperable car.
And
I
law
mean,
enforcement officers saw it.
right at the scene of the accident, right? I mean, if you have some kind of other evidence to show, I have to give them time also. You know, I mean, this is just probable cause is a very low burden, right? So this doesn't mean that you're guilty. I mean, if that's in fact true, that's why we have trials, right? There's always two sides to the story. I wasn't there. You were there. You know what happened. I don't know. So that's something that you bring out in trial, and you know, perhaps even before, if you show it to them and it's in fact true, then you know they'll kick it. But I'm going to find that there's probable cause to go forward with the case for now. Ms. Rice, any prior DWIs?
No, Your Honor.
License?
Check on the license ready second.
Like I said, I'm finding probable cause. I'm warning you not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail. You understand? You're not allowed to drive unless you have a valid Texas driver license and liability insurance as well, okay? That is a part of your bond condition as well. If you find that you're driving, you don't have insurance or any other violation, you will go to jail. No more PR bonds. Do you understand?
Yes, sir.
Now, you've got great lawyers. They'll take care of you because you have them. I will waive your appearance. You don't have to waste your time coming to court. But stay in touch with them, and they'll tell you if and when you have to come back to court.
Yes, sir.
Judge, I'm sorry, I'm running this license. It's not loading right now. Okay, here it comes. Judge, the license is up.
Okay, great. So what we'll do for now is we'll have you go to Victoria Sign and Reset. You'll get with Roxanne for your bond convictions, and after that, you're free to go.
Thank you, Judge.
You speak English, sir? Yes or no?
Yes, sir.
Is there a Joya here? Joya? Sir, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
Just one moment, Governor. Judge, on April 21st, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a shoplifting call at JCPenney. He made contact with a witness, loss prevention officer. The complaint witness stated the defendant entered the store and selected a hoodie, removed an anti-theft sensor, and put the hoodie on. The defendant then exited the store, passing all points of sale. The defendant was detained by the loss prevention officer, and a pair of shorts and a t-shirt were located under the hoodie that were also not paid for. The total value of the stolen property was $100.
So like on I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any JCPenney. Do you understand?
Yes, sir.
If I find that you do, I will revoke your bond and put you in jail. If you pick up any new cases, if you're a danger to my city, it's not going to go well for you. How old are you?
18.
I'm going to appoint a lawyer today. What are you doing with yourself?
I'm working.
Where do you go to school?
MacArthur High Schools.
I don't want you using alcohol. I don't want you using any weed. I'm going to test you today. You understand? If you do, it's not going to go well for you likewise. You mind reaching out to the man? I'm going to have you take a seat right over there, and I'm going to send you for a test. You were to come back. Do you understand, sir?
Yes, sir.
And then I'll have a lawyer for you. Please.
I guess we can talk about it. I got appointed to a case a little bit late. He was already on it, so they reappointed him to this guy in custody, Jerry Birch. I might still be attached. That's what I'm approaching.
I don't see anyone attached. But regardless,
The issue, Your Honor, is we want to roll
he's in
it.
jail.
He's in jail.
I'm sure he's on bond.
But we want to roll it to tomorrow because
I
I
think
think
you had to issue the warrant because he maybe missed a court or something. I don't know.
Okay, whatever you want. Sure. If you want to roll it, we can roll it tomorrow.
All right, thank you.
Okay. And I have Lorenzo Lacona. You had sent him for a drug test earlier, Judge.
Coming up. Is that mom?
That is mom. Do you want to come to?
No, I don't think she understands her. She speak English? Okay. Guys, what did he test positive for?
It was something positive for THC or benzo. Okay, then we need to.
No, sir. No more. I'm gonna test you like crazy. If I find that you're using, what happens? That's right. Do you speak Spanish? Dime con quién andas, yo te digo quién eres. Don't be hanging around with the wrong people. It's not gonna go well for you. I want you to stay in school full time. I don't want you out, and I'm giving you a curfew so you're not out in the middle of the night. 10 p.m. Do you understand? And I'm gonna test you weekly so I know that you're not using. The next time, I'm giving you a 50-day pass on the weed. After 50 days, if you continue to test positive for weed, you test positive for anything else without a valid prescription, it's not gonna go well for you. Do you understand me?
Yes, sir.
You will not fall through the cracks here. Okay, thanks, counsel.
Now you do work and go to school. He works at Discount Tire. Is that good for you? As far as the curfew's in?
It's all good.
It's good? Okay.
Hicimos un examen de drogas y tenía positivo de marihuana y píldoras. Le dije que no más. Le voy a hacer exámenes cada semana para ver si está usando. La próxima vez se quede conmigo. También le voy a dar un curfew que no se puede ir de la casa de las 10 de la noche. Se tiene que quedar en la casa. Si él sale después de las 10, voy a revocar la fianza. ¿Necesitas algo más?
Gracias por ayudarme.
¿Cómo no? Cualquier cosa que tú necesitas, me avisas y lo hagamos, porque no quiero que él se falle de más. No puede comunicar con la otra persona. Do you know who the co-defendant is in this case?
I do not.
Guys, who's the co-defendant?
It's
Like, is it friend, relation,
Oh.
brother?
not sure.
I don't.
Information.
So I told him no using drugs, no using alcohol. I'm getting him a curfew.
I don't know.
Guys, put a monitor on him, please. And no contact with the.
I don't believe there is a co-defendant in this.
No, there is.
There
There
is.
is.
There is. Just the dude didn't show up today. Si necesitas algo, avisas. Come on.
Judge, are you
Yeah. Yeah. 10 p.m. 10 p.m. So you have a lawyer.
Tienes un abogado aquí.
If you need
Si
anything,
necesitas cualquier cosa,
let the lawyer know.
déjalo saber.
If he starts misbehaving in your house,
Ese hace mal en la casa.
you let me know,
Le dejas saber al juez
and I will take care of him for you.
y yo me encargo de él.
Okay.
Ok,
Okay?
Gracias.
está bien.
We're going
Thank
to
you.
put a monitor on him so we
Vamos
know
a
where he
ponerle.
is at all times, and we don't want him out in the middle of the night.
Y no nos queremos afuera
Target as well.
y no puede regresar a Target. Va a tener un toque de queda, ¿entiendes?
Sí.
Okay? Okay?
Okay, gracias.
Thanks. Miss Washington, ma'am, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On April 21st, 2025, in Harris County, Texas, a law enforcement officer conducted a business check at a convenience store. Law enforcement officers observing surveillance saw two males engaging in hand-to-hand transactions and leaning into the passenger side window of a black sedan. Law enforcement officer made contact with the defendant, the driver of the black sedan, and observed marijuana in plain view in the cup-holder vehicle and carried out a probable cause search. The law enforcement officer found a baggie in the cup holder to contain a green leafy substance identified as marijuana. The approximate weight of marijuana was 0.427 ounces.
Two males have a hand-to-hand transaction.
Good shot.
They get into the car.
This part hits different. The judge isn't just talking about the law, he's talking about life or death. Burglarizing cars might seem like a minor crime, but in Texas, it only takes the wrong car and one scared owner with a gun for things to turn fatal. This isn't just a warning. It's a wake-up call, a dose of reality that some choices carry consequences you don't walk away from.
Yes, Your Honor. They're speeding.
Officer goes to the car.
Yes, Your Honor.
Where's she?
She's the driver.
She's a driver. Ms. Washington, we're going to find that there's sufficient probable cause to go forward with the case. Can you run her license, please?
Yes, Your Honor.
Do you have the ability to hire a lawyer, ma'am? Okay, I can have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you, what kind of car you drive.